Bismillahirrahmanirrahim. Hi guys, Assalamu alaikum. Today we discuss the type of maritime injury cases. Houston's Maritime Law Firm. Maritime workers face situations and endure conditions that would send most landlubbers into a state of fear and despair. While the most part they understand the hazards they are exposed to and have various way of coping with them and minimizing the risk accident do happens. Among the most common injury producing the accidents suffered by maritime workers are: number 1, slip and falls. Solidly number 1 in injury claims. In wet condition, slips are common and occurs on stairwells, on deck and even in crew areas. Bumps and collisions. Swinging bombs, cranes, dollies, cars, machines and unsecured cargo can dash into the workers. Lifting and carrying the misshape, titling deck in rolling the seas can make the lifting heavy object treacherous. Even under the ideal conditions, heavy lifting in are risky and ever. Illness. Not every claim is due to an injury. Sometimes crew members become ill due to unsanitary conditions and improper food preparation. When the ship is out to sea, an injured worker only medical option is the onboard medical staff, also known as the infirmary or risk bay or sick bay. This can be real asset or pose a real risk if the personnel are inadequately trained. In extreme cases, a transport helicopter might be needed. But weather and sea conditions can apply a role in whether a helicopter can be dispatched. Now, filling your maritime claim. An injury at sea is almost always breaking news around the ship. It's impossible to keep something like that a secret. But regardless of severity of the injury or manners in which it occurred, it's vital to maintain a grasp on the fact, because ultimately it's up to you to set the record straight on what happened. A word of your injury reaches management, they will naturally want to talk to you. Be very, very careful of what you say. If anything, while you don't want to be rude or uncooperative, you must protect your interest. And by all means, don't submit to a recorded statement. You can't be compelled to provide a recorded statement at any point in the process. Your compensation, if you decide to contact a maritime lawyers and file a claim, will be tied directly to the degree to which the employer or ship owners is negligent. Insurance company, adjusters and attorney on their sides are the masters of manipulation, and anything you say prior to the case going to the court can be twisted and used against you. Don't think you can outfox a seasoned pro. Don't sign any documents, approve any settlement offers or sign any statement without consulting a maritime attorney. Now discuss the filling your maritime claim. do, however, fill out an accident report as part of the claim process. The difference here is when you fill out an accident report, you are in control. You have time to ponder your answers and clearly establish the fact without being put on the spot trying to answer the trick questions. Get the name of any co-workers or witnesses who saw the accident or perhaps even noticed a hazards that might have contributed to your injury. Contact Daniel Patrick Law in Houston immediately. They will go over your case and help you with accident report and help establish a concise synopsis of an accident. Based on the confidential information you provide them, they can advise if your case is likely to be successful, and if so, advise how much compensations you might be entitled to. The things that change when you hear a maritime attorney. A density of the business in Houston, especially the business in the maritime industry, creates a community where information makes the round pretty quickly. When one of the companions is taken to court, community where information make the round pretty quickly. When one of the companion take out the court in a maritime injury suit, the other companies in the Houston's area take notice. Frankly, neither side a maritime injury case want the matter to go to court. Many don't. In fact, most don't. Often, when a maritime lawyer enters the case on the side of the victim, opposing sides suddenly decide it's in their best interest to settle out of court. The initial sign, here we will be done with this, offer is often withdrawn and replaced with something more substantial and fair. Intimidation's technique generally subside, and for the most part, they will leave you alone and deal with your attorney directly. Don't attempt to initiate a maritime injury claim yourself. Maritime law differ widely from the kind of laws you might be familiar with. It's also a constant state of flux. The Merchant Marine Act and Jones Act have been revised multiple times since their inceptions, and there are calls right now for new revisions and even calls for their